Welcome to my world. Come on in and make yourselves at home. Welcome to my life. I know everything's gonna be all right. Welcome to my world. Oh, won't you come on in? Welcome to my life. It's known as the Tiger's Den. Greetings to all of my subscribers. I want to thank you for being with me for as long as you have, and the new subscribers that's coming on in. We want to say greetings and thank you for your time. This is from Toothless and the moderators. Welcome to the Tiger's Den. Greetings and welcome to the Tiger's Den. This is the voice of Cheryl, and I am Toothless Tiger. As you know, we've been talking about the criminal injustice system. I did a series on plea bargains and how they are taking away our Sixth Amendment right to trial by jury. We see the example of plea bargains gone wrong, looking at the Young Thug trial. And I just recently started looking at that trial, and it is a mess. It saddens me as a mother, as an Asiatic mother, who for most of our lives we've been taught that we were second-class citizens, that we did not matter, and that we're not going to get a fair chance. And we always assume that to be by the European leadership. And so when we got an opportunity to vote and had an opportunity, we thought, to hear someone represent us, we started voting, and we put people in office that looks like us and we believe have like experiences, came from similar backgrounds. And so we vote them in because they too went to school, they say, and obtained degrees and knowledge, and they could understand our plight, and so they wanted to make it different for us. Unfortunately, that is not the case. For whatever the reason, that is not the case. And we still do not receive fair representation in most arenas. When you complain, then people say that you are conspiracy theorists. You're just making up stuff. You don't know what you're talking about. It's not that way. They didn't teach us that in school. And that's a lot of the problems. A lot of things they didn't teach us in school. We didn't get erudition, which is education for human development. Unfortunately, we received animal husbandry, which is education for animals, docility training, go along. You know, and one of those favorite sayings that everybody like to repeat, the go along, get along game. Well, that's how we were trained, to just go along. Don't make waves. Don't speak up for rights, because in all honesty, you don't have any. But we all have rights as human beings, unalienable rights. And sometimes it's costly to receive the right. But if you don't stand for something, then you'll fall for anything. There is a saying that Malcolm X used to say, and I traced it back to see who originally came up with that saying. And I'm sure that I am not going to pronounce his name correctly. But he was born in the 1800s, and he's an African from Ghana. And I have it. I thought I sent it to myself, and I know I did, but I may have looked at it, and if I've looked at it, then it's moved to the bottom of the list, and I hate that. You know, me and this technology, it really gets to me. But his name is, one moment. Okay, I had to put you guys on mute for a moment. Phyllis just bust in on the telephone talking, so I put you on mute for a moment. But his name is Emmanuel, and I cannot pronounce the name, so it's Dr. James Emmanuel Equiyer Agray. And I know I mispronounced his name, but what he said is profound, and this is what I want to read to you before I start reading about our plea bargains. And then we're going to talk about what happened with these people here in Atlanta. What he's speaking on is the fact that if you teach a man, you teach an individual. But if you teach a woman, you teach a family. And then later it was changed to a nation. And what he meant by that, because of the role of the mother, her nurturing, her teaching as the first teacher, and her ability to recreate, then you teach a family. You teach everybody. Okay, this is just the beginning of what he said, and then I'll read what he says. His idea of education was the all-inclusive type. Secular education was abhorrent to him. To him, education meant the full development of the human personality. By education, he said, I do not mean simply learning. I mean the training of the mind in morals and in a hand that helps to make one socially efficient. Not simply the 3 R's, but the 3 H's, the head, the hand, and the heart. He wanted this all-around training for girls as well as boys. No race or people can rise half slave, half free. The surest way to keep a people down is to educate the men and neglect the women. If you educate a man, you simply educate an individual. But if you educate a woman, you educate a family. Now, he has all accolades, and I'll put this in my description so you guys can look him up. But he was awesome, and it was like he came from nowhere, and everybody loved him. It did not matter race, creed, or color. Everyone loved him. And to show you how much, in South Africa, he so much impressed the white settlers at public lectures that his audience widely and admiringly exclaimed, "Damn his color, he's a saint." And he was awesome. Unfortunately, he got ill at a young age and passed away. But that seems to be what happened to the good guys. Let's go with our plea bargain series. We left off on page 31, and it was talking about a trial. I really appreciate everybody that's in the chat. I appreciate you being interested in what I have to say. I see a lot of things on YouTube. Some are funny, some are not. A lot of people have a lot of titles that sounds like they're really talking about the subject matter, and you look at it and it's nothing about what they're talking about. And some would say the same for me. As you all know that know me and come into the chat, I talk about different things, but my biggest thing is to try to leave you with some type of knowledge that you can take and go and start researching and perhaps use or share with someone who may need what we have to say. We're in the information age, and it is so much out here that we can learn. A lot of us maybe are not interested in reading, and that's been one of our biggest problems because, like I stated before, from birth to the 3rd grade, you learn how to read. But from the 4th grade on, you read to learn. And if you fail to read with understanding, then you're going to be left behind in a lot of things that happen in this world, because some things you have to learn to read between the lines. Some things are not written. They're not even spoke to. Adhere or adjust, or you will be left behind. I came here to YouTube, as I state always, to share me, my life experiences, things of that nature. I didn't come to try to make anybody be anything that they're not. I hope anything I say can enhance who you are. And if you haven't dealt with the issues of you, then maybe, just maybe, this will encourage you and know that you can change your surroundings by changing your thinking, and especially the way you see yourself. Because we always kind of tend to go along what other people say about us. Good, we smile. Bad, we're sad. But what if you do that to yourself and start making a list and checking it twice, and then you decide the things that need to go or the things that should stay? Because everything about you, good or bad, shouldn't go. There are some things we need as mechanisms to protect our heart, to protect our mind, to protect who we are as individuals. There are some things that are universal. And it is always good when you can check yourself before you wreck yourself. A lot of people spend a lot of time on this thing we call the internet. Sometimes this is the only place that they get to interact with humans. And I understand that. It seems like a lot of people have a lot of issues. And sometimes you don't have anybody to talk to. That's why I believe in the power of the pen. You get you a paper and pen and write it out. Talk to the paper. And make the paper be whomever you want it to be. And once you get it out of you, you can either keep it to measure your going forward, or if it's too painful, you can take it and tear it up or burn it in a safe place and let it go. Forgiveness starts with self. And most of the time, that's the person that we don't forgive is ourselves. We hold ourselves responsible for a lot of things that's not our responsibility. We take blame when we ought not to. But nobody tells us that. So we find ourselves just trying to figure it out on our own. And it happens to the best of us. It doesn't just happen to one person. It happens to us all, to be honest. I just want to say greetings to Uncle Shug, Asatar, Phyllis, anyone in the bushes and the trees and the lakes in Aruba, in Belize, in the sky, wherever you may be. Greetings and welcome to the Tiger's Den. As we go on with the plea bargaining series, again, I'm going to start with the trial, which is where I left off. Kevin Ring and the trial penalty. Kevin Ring was a lobbyist involved in the Jack Abramoff bribery scandal in the mid-2000s. Abramoff and several of his law firm colleagues were accused of providing bribes and gratuities to White House staffers, congressional aides, and other government officials in an attempt to, among other things, influence legislation permitting gambling on Indian reservations. Ring, who worked for Abramoff at the time, was indicted for conspiracy to commit honest service fraud and pay illegal gratuities. Abramoff and his fellow mastermind in the scheme, Michael Scanlon, were also accused of orchestrating a kickback conspiracy where they actually lobbied against their clients' interests to extort higher fees from them. Ring was largely uninvolved in the kickback conspiracy. Both Abramoff and Scanlon pled guilty and were sentenced to 4 years and 20 months, respectively. The other lobbyist defendants also pled guilty, and the government recommended that they be sentenced either to home confinement or only a few months in prison. The court sentenced one to 30 days in prison and the others to probation. Ring, however, chose to go trial. After an initial hung jury, the second jury found him guilty. At sentencing, the prosecution calculated Ring's guidelines ranged to be between 17 to 21 years, far longer than either Abramoff or Scanlon had received. In supporting that calculation, the prosecution urged the court to consider the benefits the lobbyist's clients had received in exchange for the bribes, even though it had not argued that those facts were relevant to sentencing any of Ring's co-defendants. The prosecution dismissed any suggestion of fact bargaining, claiming that it had only recently acquired evidence establishing the extent of the benefits. In a pre-sentencing opinion, the court explained that although it was not clear that fact bargaining had occurred, courts have little ability to uncover or police such tactics when they are used. In criminal cases involving plea agreements, it skips down. In criminal cases involving plea agreements, the court and the probation office are frequently at the mercy of the parties to disclose and explain relevant facts, and may not always get a full picture of the defendant's offense conduct, nor do they have the means to learn the information on their own. The judge ultimately rejected the prosecution's argument and sentenced Ring to 20 months in jail. Employing a dramatically different methodology for calculating the guidelines range of those who plead guilty would undermine the very purpose of the guidelines and give prosecutors even more power over sentencing than is already the case. So in federal cases, the prosecution has the power the most in sentencing. In the state cases, the prosecution has a lot to say, but they don't govern because they don't have, the legislature actually sets the guidelines based on how they voted when they were in session and the particular type crime and what time that it carries. And basically, I know in the state of Texas, I don't know if it's like this in all states, but in the state of Texas, you can go to the boards of pardon and parole, and you can pretty much look up the sentencing for different crimes, and it shows each legislative session and what the law was at that time. So as we go on to page 32, prosecutors leverage excessive sentencing guidelines to force pleas. And this, of course, is on the federal level. The enormous discretion that prosecutors willed to pressure defendants to plead guilty through traditional mechanisms like charge and fact bargaining is even greater in light of the sentencing guidelines. Although the guidelines were adopted as a means of addressing unwarranted disparity in sentencing, they have been largely ineffectual in meeting the goal. The Supreme Court has made clear that individual judges are best suited to weigh disparities on a case-by-case basis. But the pipe dream of administering uniform justice has held sway, reinforcing the influence of the guidelines, which rely on mathematical calculations at the expense of fairness in individual cases. These people that sit up and make all these rules and come up with all of these invasive way of doing things, 9 times out of 10 have no real knowledge of what they're doing to individuals and their families, and they don't seem to care. If you're not involved in something, it just really doesn't too much matter to you, unless it becomes a part of, your life. Then, of course, then you want to know everything there is to know about it. It would be real good to just inform yourself of different things, and especially the criminal injustice system. Whether you are involved in that system or not, somebody you love or someone you know of is going to come in contact with something or someone that this may be of interest to somebody. And a lot of people believe, well, you did the crime, you do the time, and then that's a true statement. But it's things that go along with that, and I think that we take the humanness out of it when we just look at you do the crime, you do the time, lock them up, throw away the key. We take the human being out of the equation. We take the circumstances, and perhaps there's never a time for you to do wrong. But if we're all imperfect beings, as everyone loves to say, at what point do we look at that part of a person as being an imperfect being? It just makes you wonder. Indeed, although several federal judges are quite outspoken about their disagreement with the guidelines, referring to them as arbitrary and having been drawn from nowhere, many, many more remain reluctant to deviate from them. One federal judge recently admitted that she would not have imposed a 360-month sentence, but she felt compelled to do so because the guidelines called for that sentence. In fact, Because judges are still required to begin their sentencing analysis by calculating the guidelines range, there may be a psychological predisposition to sentence within the range. It is also possible that the guidelines have maintained their pervasive force because they represent the path of least resistance. Within guideline sentences are virtually immune from review on appeal. So judges who do not like to be overturned can ensure a good record by sticking to the guidelines. Others may cling to the guidelines because they are used to them. Most of the federal judiciary is made up of judges who began their tenure under a system in which the guidelines were mandatory, and they may find it difficult to divorce themselves from such a familiar crutch. But whatever their reasons are, motivations for doing so, the fact remains that many judges continue to adhere to the guidelines, preventing any truly meaningful check on federal prosecutors who can use the increasingly harsh guidelines sentences to coerce defendants to plead guilty. There are so many things in law that we the people don't understand and are caught up or affected by it, and we don't really realize it. Economic crimes as an example of the guidelines overreach. One of the most flagrant examples of how the guidelines call for the imposition of excessive sentences is Section 2B1.1, the guideline that applies to economic crimes. Section 2B1.1 has long been criticized for resulting in sentences that are grossly disproportionate to a defendant's actual culpability. Judges have referred to sentences under this guideline as penalty absorbed on their face, a black stain on common sense, and fundamentally flawed. Because defendants' sentences are so inflated under the guidelines, prosecutors have enormous leverage in economic crime cases to force guilty pleas. Increased penalties for indeterminate loss amounts, and that's indeterminate, not interdeterminate. Although it is commonly referred to as the fraud guideline, Section 2B1.1 covers a vast array of offenses and offenders, more than any other guideline. It determines the sentences for more than 300 federal criminal statutes and applies to offenses ranging from illegally downloading digital music to massive fraudulent investment schemes. Individuals sentenced under this provision of the guidelines made up 12.2% of all defendants sentenced in federal courts. Despite the breadth of criminal conduct covered, sentences under Section 2B1.1 are principally driven by a singular factor: the amount of loss that actually resulted or was intended to result from the offense. This factor has become increasingly significant in enhancing sentences for economic crimes. The amount of loss is factored into a defendant's total offense level, which is one of the two variables for determining an ultimate sentencing range. When the guidelines were first adopted, The amount of loss could result in, at most, a 13-level enhancement to a defendant's total offense. Over the intervening years, the loss table was adjusted to add more categories of loss with higher and higher enhancements. And enhancements are like taking it from something that's not so bad, weighing it against what has happened in your past and adding to it. This means that where a defendant's sentence falls in a range between 0-6 months and 15 to 20 years will be determined by a single factor. This consistent upward ratcheting of the loss table is out of sync with the Commission's initial purpose for economic crimes. Originally, the Commission sought to provide a short but definite period of confinement in cases that had traditionally resulted in sentences of probation. Over the years, however, the amount of loss enhancements were inflated, not as the result of any empirical analysis suggesting sentences were too low, but rather in response to directives from Congress, who were facing political pressure in the wake of major financial crisis. The framers of the guidelines settled on loss as the driving factor for economic crimes because it's hard getting this to the way they come up on this page. I wish it came page by page, but it doesn't do that. Because they believed it to be a reasonable approximation of the seriousness of an offense, and it was common to all covered offenses. But while the amount of loss may have been an effective means of selecting a sentence somewhere between probation and a few years imprisonment, as the upper range of sentences has risen, it has become far harder to justify basing sentences so heavily on this single factor. As judges, scholars, and even former prosecutors have observed, overemphasis on the amount of loss often leads to sentences that are disproportionate to the seriousness of the offense. Defendants are plugged into specific slots along the broad spectrum of the loss table without any consideration for other factors that are arguably more significant when measuring a defendant's relative culpability. For instance, the scope and duration of the offense, how much the defendant gained from it, or the defendant's motivation. In addition, individual defendants are frequently held accountable for all losses caused by participants in the same scheme, even if the defendant was not involved in his co-defendant's conduct, did not intend for the losses to occur, or did not personally profit from them. A defendant's subjective intent with respect to loss will only be considered under the guidelines if he or she intended more loss than what actually occurred, meaning intended loss can only increase a defendant's sentence, not lower it. So everything is against you. What's more, in the situation of an unsuccessful fraud where no loss occurs, intended losses can still increase a defendant's sentence even if the fraudulent scheme is so outlandish that it never could have succeeded in the first place. For instance, one federal district judge imposed a 20-year sentence on defendants who used AOL email accounts to impersonate Buratan nationals and Yamasee tribesmen seeking a $5 billion loan to build a pipeline across Siberia. So I probably said all of that wrong, but I said it the best I could. Unsurprisingly, the only person who was defrauded by the scheme was a government informant. Even though the defendants had no chance of succeeding in the scheme and no loss could possibly have occurred, the judge imposed a 20-year sentence largely based on an intended loss of $3 billion. But, and they have so many double standards in this law. It is unbelievable how it really works. And none, to, it seems, an innocent individual's favor. It's unbelievable. And that's just my understanding of it. Somebody else could understand it totally different, and that's okay. That's just my understanding of what I read. The Second Circuit reversed, finding that no legitimate investor would have fallen prey to such an outlandish scheme. The concurring judge noted that even if it were perfect, the loss guideline would prove valueless in this case, because the conduct underlying these convictions is more farcical than dangerous. Despite cases like this, the guidelines permit sentencing judges to rely entirely on intended loss. Not in all cases. Even when actual loss has occurred, loss calculations need not be precise or certain. The sentencing judge is only required to make a reasonable estimation of loss. Nor is the prosecution required to prove losses beyond a reasonable doubt. The significantly lower preponderance of the evidence standard applies at sentencing. In other words, a defendant considering whether to exercise his right to trial knows that even if he decides to put the prosecution to its proof and is acquitted of certain charged conduct, he may still face an enhancement for that conduct at sentencing. In cases where losses are particularly difficult to calculate, prosecutors have even greater leverage to force pleas. They may even use novel theories for calculating losses during plea negotiations to overstate the severity of a defendant's likely sentence. Lower-level members of a fraudulent scheme are more susceptible to these threats because they rarely know the full extent of the loss. Unless contrary information is presented at sentencing, a sentencing judge is permitted to rely solely on the loss amount that the parties stipulate to in a plea agreement. Thus, few defendants will risk going to trial if they can secure the prosecution's agreement to a low loss amount by pleading guilty. So it's all just a game, and everybody running around here talking about how they're playing chess and somebody else is playing checkers. And these people are playing with our lives and our freedoms daily. It's unbelievable. In addition to these tactics, the government may also engage in sentencing entrapment. In such cases, the government uses an undercover agent to investigate criminal conduct, but then exacerbates the magnitude of the defendant's conduct to boost the guidelines calculation and create a sentence that will be high enough to coerce a guilty plea. The government may do this by prolonging its investigation even after it has sufficient evidence to obtain an indictment. This practice is entirely permissible in many federal circuits because judges are unwilling to invade the government's discretion to investigate crimes. In other cases involving crimes like those subject to Section 2B1.1, where sentences depend so heavily on quantities involved in the crime, the government may also instruct its agents to deliberately increase those quantities to in turn increase the applicable guideline ranges that will apply. Overlapping enhancement double count the same conduct. On top of the enhancement for all amount of loss, Section 2B1.1 contains 29 specific offense characteristics, SOCs, that call for additional enhancements to a defendant's total offense level. At first glance, the SOCs could be viewed as an attempt to more accurately distinguish between the seriousness of different types of economic crimes. But the SOCs almost always aggravate sentences rather than reduce them. So more offense levels are piled onto sentences that are already bloated and out of proportion with culpability because of the onerous loss. So I think that this ought to make one really contemplate whether they want to have a criminal history, especially on the federal level, because it sounds like it's just really way too much for one to grasp. We're going to stop when I finish page 35. Loss enhancement. The SOCs are thus serving no distinct purpose other than to give prosecutors more leverage to threaten higher sentences. Additionally, many of the SOCs involve factors that are already taken into account in the loss calculation itself. Frank Bowman, one of the drafters of the modern version of the fraud guideline, and now an outspoken critic of it, has explained that the loss calculation was originally intended to serve as a proxy for multiple factors relevant to the seriousness of an offense. Over time, however, the Commission added more and more SOCs to the guideline, but failed simultaneously to decrease the enhancements under the loss table. So factors that were already incorporated into a defendant's sentence through the loss enhancement are now frequently double counted. That sounds like double jeopardy. Double counted. By way of example, the guidelines stack additional offense levels on top of the loss enhancement when the offense involves a certain number of victims. But higher loss crimes are already much more likely to include a large number of victims because they involve high losses. The same could be said for the sophisticated means enhancement, which adds 2 levels where the defendant intentionally engaged in or caused conduct constituting sophisticated means. As losses are higher, it becomes far more likely that the defendant will have needed to use sophisticated means to achieve them. The definition of sophisticated means does not provide much guidance on when the enhancement should apply. Especially complex or especially intricate offense conduct pertaining to the execution or concealment of an offense. The application notes provide only 2 specific examples, one of which is now included in the text of the guideline itself. This makes it ripe for use by the prosecution as leverage during plea negotiations. The SOCs can also overlap with each other and other guideline provisions. For example, Section 3B1.3 calls for a level 2 increase to the offense level if the defendant used a special skill. Special skill is not defined, so in many cases, both the sophisticated means SOC and the special skill SOC could apply to the very same conduct. The Commission has generally acknowledged this phenomenon of factor creep, explaining that as more and more adjustments are added to the sentencing rules, it is increasingly difficult to ensure that the interactions among them and their cumulative effect properly track offense seriousness. However, because the guidelines do not counsel against applying multiple SOCs, even when they overlap, prosecutors can rely on them to threaten higher sentences if defendants refuse to plead guilty. So we can see that this is just really a mess, this system that we have, and the way that they come up with what they come up with. A most egregious instance of double accounting occurs in securities fraud cases involving public companies. A small impact on a large public company can easily result in losses exceeding $20 million, and securities fraud will involve a large number of victims by its very nature. So even before considering any SOCs, defendants in these cases are almost always facing offense levels in the high 20s. But because so many SOCs potentially apply in these cases, sentencing, and that sentences, can easily reach life imprisonment, even where the loss amount is relatively low. For instance, under the current guideline, an officer or director of a public company convicted of securities fraud could receive, I'm going to have to go on to 36 so that we can understand this before we leave. Base offense level 2B1, 1A1, 7. More than 3.5 million loss, 2B1, 1B1, plus 18. Substantial financial hardship. 2, 25 or more victims, plus 2B1, 1B, 2, plus 6. Sophisticated means, 2B1, 1B, 10, plus 2. More than $1 million in gross receipts, 2B1, 1B, 16, plus 2. Violation of securities laws by officer of public company, 2B1, 1B, A, 19A, plus 4. Aggravating role in offense, 3B1, 1, A, plus 4. Total offense level, 43, which equals life. As the above calculation illustrates, Section 2B1 can result in harsher sentences than those typically imposed in cases of unaliving people, kidnapping, and SA. Even if one were to argue that a multi-decade sentence is truly appropriate in a particular case, the guidelines are so onerous that the sentencing judge may be required to depart downward from the guidelines range to reach the sentence, that sentence. Because the guidelines are untethered from determinations of actual culpability, prosecutors have the power to threaten sentences for economic offenders that are generally reserved for the most heinous of violent criminals. Although they may be lenient when a defendant agrees to plead guilty, They exhibit no restraint in seeking the highest sentence possible when defendants dare to exercise their right to trial. And I'll stop it there. And we'll take up with the Commission 2015 amendments. And some, I hope, don't find this actually boring, although it may be boring, and especially my reading over it may come across as a little boring, getting tangled. But I promise you these things, and what I'll do is I'll try to see if I can get the link and put it in one of the descriptions so you can just look at the booklet itself, because again, it may not mean nothing to you today, it may not ever mean anything to you, but you never know who it may mean something to, and someone that you love. And so what you try to do is just do your best to at least have knowledge, not that you can represent them or anything, but you could just perhaps show them. I'm looking for my stop sharing, but it's not popping up. There you go. Hello, I see more have joined us. Hello there, Madria and Moonchild Pink. Thank you all for joining. I greatly appreciate it. So now that we've covered our plea bargains, and remember, to me, it's all important with what's going on with especially these RICO cases in Atlanta, because a lot of the people pled. And they did that because they thought it was going to excuse them from, having to go through this. And they're not having to go to trial for themselves. Unfortunately, what the prosecution is doing is using these people as witnesses and then impeaching them so that she can go back on the plea deal. So I want to talk about a young man who's supposed to be one of the star witnesses, and he hasn't come up yet, and I believe they call this young man Woody. And they said that he's supposed to be in protective custody and stuff. I don't know if any of that's true. That's just what the people say in the chat. I don't really know the characters in this play, and so I don't really know, what's what. I'm learning as I look at the case and I go back and read a couple of articles and stuff. I haven't really dove deep, but I know enough. And I saw someone talking about this, and it was Teddy Nash was talking about that police officer, that we all tend to believe something is just off with this lady. Well, I didn't find anything on her in particular, but what I did find after looking at SETI, I went and looked up this case and read it and thought it would be interesting to share. When he was arrested back in, I believe it was 2015, he was arrested. And so it was very interesting about the story that they told, because the way he was arrested, he wasn't arrested that day that they came and searched him and all that good stuff. They waited a while, and then he was trying to suppress the things that happened on that day. And you'll get to hear the court's decision on this, and this is in federal court. And I did put this case and the actual link to it in the description. But I thought it was awfully interesting how this detective came up into this case. And so you guys will get to hear and tell me what you all think. What does it sound like to you all? Because it sounds very questionable to me, her integrity. in her honor. Hey, Texas gal, good to see you. I'm just about to read a case. Glad you're here. Thank you for coming. That's one of Asatar's favorites, and she came to visit us. So thank you so very much. We appreciate you. Asatar is always trying to get people to come over and see me. And so when they do, we're elated. The only thing about when you do, Texas gal, a lot of people don't really know how I do things. Is just that I just kind of like people to engage in the conversation that I'm having. And we do that pretty good over here. Sometimes people don't, but that's what we like. And long as people don't be disrespectful, and I know that's not you at all, but long as people are not disrespectful, I don't care about the other crazies coming in or nothing like that. We just try to learn something. That's all I try to do, is help people learn something. My mission in being here is to uplift fallen humanity to the best that I can help. And so that's what I try to find myself doing. And then I ran across the Young Thug case after seeing a lady that I love. She's called Liquid Concrete. And she covers a plethora of topics. So you can't just see her on one thing or another. And she's very thorough in what she does. And I found out about the Young Thug thing. And so I started watching, and I've been really just caught up ever since how terrible these district attorneys are. And as we know that it's not just Fulton County, we got to know that it's all over. I just found out today that in Tarrant County, which is a jail, the county jail in Fort Worth, Texas, which is 32 miles from Dallas, they've lost 63 inmates, 63 since 2017, with the latest one being last week with a veteran who suffered from schizophrenia. And it is very, very, very sad. And his sisters want answers. And they tried to get him in a private facility, but they would not accept him. And so he ended up going to jail, and now he's no longer with us. And that is totally, totally unacceptable. But if we as people don't get involved in things that don't involve us, and I don't mean go and throw yourself and do something wrong, but there are things we can do, and nobody has to know. The person that you write to will know, but we can write to legislators, the state senators, the state representatives, the council, whoever district it is, and whatever person that can make or add any decision making to an area, we can always write. It does not mean that it will make nothing happen, but we never know if we don't get involved. And we never know when we may need to be big in the public to help us on something that happened to us. So I think that's very important to do. And of course, that's just one woman's opinion. You're no better or no worse if you don't do what I think. My favorite mantra is be yourself at all times, whoever you are. Be you. And to thine own self be true. This guy Woody is supposed to be one of their number one witnesses, just like DK was. They were banking on DK to really, sink the ship. DK, to me, came across credible. He came across as a young man that grew up in an environment that was full of crime and drugs and people calling themselves gang members, and he conformed to his environment. He seemed like he was a family man, at least he wanted to be, the best he knew how to be, because he really didn't know how to be. He started being the man of the house when he was a young boy. When his mama couldn't feed them all, he did everything he could to help feed everybody. And that caused them to do crime. I'm never a proponent of crime. I never push crime. We just have to understand it and try to get rid of it. And the only way that we can get rid of it is to give more opportunities to people. So this case here is very interesting because this is one of the guys they're banking on to really give them some information. And this is a crime that he committed. And here it goes. It's the United States versus Copeland. And then they give you the criminal action number. And here is the order. It's from Amy Tettenberg, U.S. District, United States District Judge. Order. Presently before the court is Magistrate Judge Russell G. Vineyard's report and recommendation. Future, they're going to call it R&R. That DOC means that's where it is on the docket. Recommending that the court deny defendant Kenneth Copeland's motion to suppress evidence and statements. Copeland's motion seeks to suppress evidence and statements that he allegedly made as fruit of his allegedly unlawful detention while playing basketball on April 28, 2015, at the City of Atlanta Dunbar Recreation Center, the Dunbar Center, as well as evidence in connection with the police officers' allegedly unlawful search and seizure of an H&M shopping bag found at the basketball court. Copeland's motion also seeks to suppress evidence obtained and statements made following his arrest on June 10, 2015, as fruit of the allegedly unlawful detention and early search in April. Defendant filed objections to the R&R. A district judge has broad discretion to accept, reject, or modify a magistrate judge's proposed findings and recommendations. And then they're going to list a lot of case law, and I'm not going to list the case law name. I'll just say in case law. Pursuant to 28 U.S.C. 636 B1, and that's giving the magistrate the authority that they have. It's limited authority, but that's what that is. The court reviews any portion of the R&R that is the subject of a proper objection on a de novo basis, and any non-objected portion on a clearly erroneous standard. Defendant objections focus on numerous critical factual and legal grounds for the magistrate judge's R&R. Defendant also challenges the credibility and inconsistency of the testimony of, and I don't know how to pronounce this man's last name, so I'm going to call him Mercure, but I don't know how you pronounce it. But just for my sake and for reading, I'm going to call it Mercure. The principal Atlanta Police Department officer who testified regarding the search and detention in the hearing conducted by the magistrate judge. Based on defendant's objections, the court has conducted a de novo review of the record and motions to suppress. The court additionally held a supplemental hearing on September 28, 2016. Now I want y'all to remember that the court had the de novo hearing, and then they did the supplemental hearing, and I want y'all to hear those dates as we read further into the case, because this officer Gaither, that has been the state's witness for the last almost 5 days, is going to come up in this document. Okay, it says the court additionally held a supplemental hearing on September 28, 2016 to consider further testimony from officers Mercer, I said Mercure. I'm going to say Mercury, even though it may not be Mercury. That'll be easier for me because I'm going to be trying to say it every different way. So I'm going to say Mercury, and I know that's not it. And A.C. Hayes, as well as investigator Lakeitha Gaither. That's the one that's been on the stand. And I can't wait until in the morning because she's going to be the one that now we're going to get to cross-examine. We, meaning the attorneys for the defense. I'm not involved in the case. I'm not an attorney. I don't give legal advice. I just love learning and being able to help yourself as well as point someone else into how to help themselves. Officer Hayes was directly involved with Officer Mercury in defendant's detention and such, but did not testify at the hearing before the magistrate judge. Strange, isn't it? Investigator Gaither talked with or interviewed Copeland on the afternoon of his original detention, and when he was ultimately arrested on June 10th, 2015, she testified at the hearing before the magistrate judge, but, listen to this, y'all, was not available to testify at the supplemental hearing conducted by the court. The court also considered counsel's letter briefs submitted after this supplemental hearing, as well as their legal argument at the hearing. Those docket numbers are those just telling you those are the numbers that these items appear on the docket. So if you went and looked up that case in PACER, the federal court system, then you would be able to see the docket, but it does cost to look at those things in PACER. I don't know, maybe you can find them somewhere else where it's free, but in PACER it does cost. And you have to register as your individual self. The R&R provides a detailed description of the evidence presented at the original hearing conducted by the magistrate judge. Although defendant objects to a substantial range of findings and inferences made by the magistrate judge, he does not appear to object to specific portions of the magistrate judge's summary of the testimony given at the original motion to suppress hearing on December 10th, 2015. Nor does defendant object to the magistrate judge's description of the partial video's depiction of relevant events at the Dunbar Center indoor basketball court on April 28, 2015. Although he does expressly object to the inferences and findings drawn in connection with these events, to the extent that the magistrate judge's account of the hearing testimony and videotape has not been disputed directly, whether in the defendant's original objections or in his supplemental post-hearing brief. The court adopts the R&R factual findings and description. That said, the court recognizes that significant factual disputes remain at issue. And this is very important. And I guess we'll talk about that after you all hear what happened. And then, like I said, you all can tell me what your thoughts are. It's a girl named Allie, and she makes very good videos. They're not real long, just clips of different things. And I love reading her description because she's always professional. And she said she doesn't pick a side or blame anybody. She just put the information out there and do thorough research to do so. And I think the way she words her description is absolutely phenomenal. I love it. Number 1, the search of the H&M bag and defendant's statement allegedly made at the Dunbar Center. A. Discussion of evidence. On April 28, 2001, 2 Atlanta Police Department officers from APD Zone 3, Mason Mercury and A.C. Hayes. And remember, I'm mispronouncing his name because I don't really know how to pronounce it, so I'm saying it like that for my sake and reading's sake, were dispatched to the Dunbar Center to follow up on an anonymous 911 phone call of concern, according to Officer Mercury's May 21st, 2015 incident report. The dispatcher stated, "There is a black male inside the recreation center in the gym wearing True Religion jeans, armed with a machine gun. The machine gun is inside of a white and red H&M bag." Magistrate judge's hearing on December 10th, 2015, and that's the exhibit. Both officers testified that they understood the bag to be a white plastic bag with red H&M letters on the front of it. Officer Hayes also testified that he understood from dispatch that the black male was wearing a True Religion t-shirt. Number 1. The gun ultimately recovered turned out to be a semi-automatic AR-15 rather than a machine gun. As detailed more fully in the magistrate judge's R&R, the officers met up at the Dunbar Center gym and soon thereafter spotted the only basketball player in the gymnasium wearing the True Religion jeans. Officer Mercury instantly identified this person as Kenneth Copeland. He knew Copeland from his beat to be a young man with a felony record who had been involved in a neighborhood gang and whom he viewed as on the top of the police radar, though not a threat to him that day or ever a threat to law enforcement other than in previously fleeing. And that was the documents that was done at the supplemental hearing. Mercury testified that he knew Copeland to carry a gun and that his senses are kind of heightened when he sees Copeland. So he gets a little antsy when he see him because he thinks there's going to be, I guess, an encounter from what he knows of him. I'm assuming that's what he's meaning by that. At the supplemental hearing, Mercury testified that once he saw Copeland on the basketball court in True Religion jeans, he kind of fixated on it. Hayes had heard of Copeland's name before, but had never previously personally encountered him. Number 2. Officer Mercury testified that around the same time that he entered the Dunbar Center and engaged in his investigative follow-up there, he could hear dispatches indicating that other APD officers were involved in a foot chase with an individual who matched the description provided by the dispatcher. Number 3. At the supplemental hearing, Officer Mercury testified that he was aware that Copeland had just been released from jail the day preceding the April 28th event. However, he stated he could not recall if he learned this from Investigator Gaither before the April 28th incident or after he had spoken with her later on that day. He additionally testified that he worked personally with Investigator Gaither and that she was the person officers reached out to in connection with gang activity matters. The official transcript of the supplemental hearing at this juncture has not been ordered by either party and filed. Therefore, specific page citations cannot be given. Officer Hayes first spotted the white H&M bag in the bleachers and pointed it out to Mercury. In the course of Mercury and Hayes' follow-up on the 911 call, one or both officers handcuffed and detained Kenneth Copeland, inspected or looked into the contents of the H&M bag, and ultimately searched the H&M bag. After detaining Copeland on the basketball court, either one or both of the officers looked into the H&M bag. They then together walked Copeland out of the gym, with Mercury taking the lead and accompanying Copeland. Mercury placed Copeland, still handcuffed, in the back seat of his police vehicle. Mercury then placed the white H&M bag in the car trunk and looked into the bag. This viewing in the car trunk is the first time that Mercury's police incident report reflects his having noticed the buttstock of a weapon in the bag. Okay. One of the things I love when you're looking at these court shows, and especially when they're questioning the behavior of the police officers, their written report almost never reflect what's going on. I saw an interrogation of a police officer last night. It was just really, it's disheartening where you want to cry, but it was hilarious the way he had to take back everything that he had wrote according to what they actually found out and had video of. So it's amazing how they do that. Defendants' objections focus both on the R&R legal analysis and its related factual underpinnings. And I would say underpinnings. In particular, the objections challenge the inconsistencies and credibility issues posed by the testimony given by Officer Mercury, the primary APD officer who testified at the December 10th, 2015 motion to suppress hearing before the magistrate judge. Officer Mercury and Hayes both worked in the same APD field operation zone. Officer Hayes, who testified at the hearing before the undersigned but not before the magistrate judge, is a veteran APD line officer who, as of the events in 2015, had approximately 26 years of law enforcement experience and had seen thousands of uns. Officer Mercury, who worked with APD since approximately 2008, supplemental hearing. Officer Hayes' testimony was consistent with significant parts of Officer Mercury's description of their appearance at the Dunbar Center and detention of Copeland and the overall sequence of events. However, material relevant portions of Officer Hayes' testimony conflicted with the testimony provided by Officer Mercury. These material conflicts or related factual points are summarized below. So now listen to how the stories conflict. One moment, please. Number 5. As noted earlier, Officer Mercury testified at the hearing conducted by the magistrate judge and the subsequent September 28, 2016 hearing conducted by the undersigned judge. Both Mercury and Hayes stood virtually adjacent to each other, with Copeland lodged between them. Once he was detained on the basketball court, the H&M bag sat on the bleachers nearby. Mercury testified that he could plainly view the contents of the H&M bag through its open top when he stood nearby it after detaining Copeland. In contrast, Hayes testified that the H&M bag was not open at the top, but instead that the top of the bag was folded over and its contents were neither clear nor visible. According to Hayes, nothing from how the bag sat on the bleachers indicated what was in the bag. Like Mercury, Hayes mentioned that when he walked closer to the bag, he could observe a shape to it because of its contents. Specifically, Hayes stated that a point was protruding towards the sides of the bag. However, Hayes testified that he could not identify the item as a gun from his visual observation of the bag. The court notes that Hayes stood in the same proximity to the bag as Mercury, or closer at some juncture. Hayes stated that after Copeland was detained, Hayes, personally recovered the H&M bag himself and opened the bag and took a quick glimpse of what was inside. But even at that point, he said he could not definitively identify as a gun the item with a piece of black rubber handle and tan metal that he could see then. At that point, Hayes stated he could principally view the Christmas ornaments stuffed in the bag and did not have a full view of what was later ultimately identified as the gun. Mercury testified that when he inspected the bag on the bleachers prior to exiting the gym, it was already open and that he could lean over the bag and see inside the bag, and that it was loaded with Christmas ornaments and the gun was just kind of sitting straight up in and you could see the weapon. Mercury testified that Mercury, was the one who collected the H&M bag and that he then proceeded to take the bag to his police vehicle. By contrast, Hayes testified that once Copeland had been detained and was standing with Mercury in front of the bleachers, Hayes himself went into the bleachers in front of them, recovered the H&M bag, opened and took a quick peek into the bag, and then closed the bag anew before they left the gym together. Hayes testified that he himself took the gun out of the gymnasium. Supplemental hearing. Oh, and I said the gun. Oh, well, it's in the report. I tried. Hayes testified that as best he could recall, Mercury had not looked at the bag before Hayes had physically presented him with the bag outside the Dunbar Center, except to the extent that Hayes had confirmed the bag's presence to Mercury as they had stood in front of the bleachers as they scanned the basketball area to identify a player wearing the True Religion jeans identified by the 911 tip call. If Hayes' testimony is accurate, then Mercury's testimony that he stood over the bag and could see its content when he collected the bag to take it outside is obviously less likely to be true or accurate, and vice versa. Mercury testified at the initial hearing that when Hayes and he were standing next to Copeland and in front of the bleachers, he asked the crowd in the bleachers pretty loudly in a sarcastic kind of way whether the bag belonged to any of them. Mercury testified that while a few people shook their head no, Copeland provided no response. On the other hand, Hayes testified that he could not recall hearing any conversation about the H&M bag that occurred between the officers and the people in the bleachers and basketball area. That was at the supplement hearing. As noted above, Hayes testified that he personally carried the bag out of the gym, while Mercury testified he carried the bag out of the gym at the supplement hearing. And remember, Hayes didn't make it to that hearing. The conflicts in testimony discussed above give the court serious pause, as Officer Mercury's police incident report, prepared close in time to April 28th events, if read alone by itself literally, would indicate that Officer Mercury first viewed the contents of the H&M bag when he placed it in the trunk of his car. Magistrate Judge's hearing. The magistrate judge credited the credibility of Officer Mercury's testimony that referenced his viewing the actual contents of the bag earlier in the Dunbar Center based on his testimony given at the hearing he conducted. But the magistrate judge did not have the benefit of hearing Officer Hayes' testimony in reaching his findings. Number 6, nor did the magistrate judge hear Officer Mercury add other arguably inconsistent bits of information in his testimony at the supplemental hearing, including his assertion initially that he could see the trigger guard of the weapon rather than just the buttstock, as he had testified to at the first hearing, though he later withdrew that assertion upon further questioning. Finally, the court was disturbed that although the police department collected the videotape of the events at the Dunbar Center on a timely basis when the entire tape was available, officers only secured, for whatever reason, a videotape that cuts off precisely prior to the search of the H&M bag conducted by one or the other of the officers, and the officers' removal of both Copeland and the H&M bag from the center. One of the last video images showing Officer Mercury looking at the H&M bag. Supplemental hearing testimony of Officer Mercury regarding the video after it was projected in the court. While the court understands that the video was obtained first and foremost as proof of the identity of the individual who brought the H&M bag into the recreation center, the police officers involved in the investigation knew this matter was under an investigation that might likely lead to criminal charges. The court therefore finds it odd that these last relevant minutes of the events in the recreation center were not apparently recovered or preserved. Ain't that something? B, findings and analysis. Number 1, evidentiary finding and reasonable suspicion. The court finds that the testimony of Officers Mercury and Hayes cannot be reconciled with respect to their handling of the H&M bag and viewing of the bag and its contents, the evidentiary landscape of this portion of the case, at the very least, significantly changed after the court conducted its supplemental hearing. While defendant bears the burden to establish the legal and factual basis for his motions to suppress, the government still must prove that a warrantless search was reasonable because based upon a recognized exception to the warrant requirement, and that's United States v. Harris. And then they give you some other case law that you can look at. And that's basically how most courts make their decision, based on their interpretation of the law and then case law that's relative to whatever case that they're listening to. That's what, you come to know. And probably by now, everybody knows that. One moment. Okay. So, the evidentiary conflicts that the court has summarized undermine the magistrate judge's original factual findings. Number 1, the Officer Mercury actually viewed the contents of the H&M bag or looked into the bag while he was in the gymnasium. Number 2, that the bag was open as opposed to sealed when and if Mercury viewed and peered into the bag in the gym. If he indeed did so before leaving the gym. Number 3, that Officer Mercury was able to identify or view the semi-automatic firearm or its buttstock in the gymnasium prior to his inspecting the bag when he placed it in his car trunk. And number 4, that Officer Mercury himself could easily view the contents of the bag, including the firearm, when he purportedly collected the bag in the gymnasium. To the extent that the R&R legal analysis and recommendations relied on these findings in connection with the establishment of reasonable suspicion, the court concludes that the current, more complete evidentiary record provides a far shakier evidentiary foundation than was before the magistrate judge. In sum, the court concludes that the evidentiary conflicts regarding Officer Mercury's testimony as to his viewing of the firearm in an open H&M bag in the gymnasium and his collection of the bag in the gymnasium are so significant that the court cannot adopt the R&R findings and associated legal analysis that relate to this specific testimony. If Officer Mercury recollection of seeing the and collecting the H&M bag in the gymnasium was erroneous or false, the grounds for the officers detaining Copeland and searching the H&M bag also become more legally problematic. While the 9/11 tipster reported that a man wearing True Religion jeans was playing basketball, this report could have been provided by any number of individuals in the Dunbar Center with no special knowledge of this particular defendant's bringing in a firearm and engaging in criminal conduct. Furthermore, one potential suspect wearing True Religion's jeans was chased down by police in the vicinity of the Dunbar Center immediately following the 911 call. The most salient specific fact bearing on the weapon carrying conduct reported was that the suspect had carried a white H&M bag with red letters that contained a machine gun. Thus, questions regarding whether and when the officers actually saw that the H&M bag contained a gun directly go to the existence of reasonable suspicion at the time that defendant was detained in the Dunbar Center's gymnasium, and the existence of proper grounds for search of the H&M bag. The sheer fact that an H&M bag was sitting on the bleachers by itself does not necessarily push this case from the prism of Florida v. JL. Florida v. JL was a very good case that I hit and read. It was a little guy that was at a bus stop, had on a plaid shirt, and it was 2 other guys there with him. Someone called in and said that he had a gun. When the police got there, the guys was just standing at the bus stop. Nothing, weird going on. The police came up and, of course, accosted him and searched him, and they found the gun in his pocket. But his ruling was totally different in this one, because what the court said is that they had to observe that themselves, and someone told them who they were. This is totally different. That's why it's good when you look at these cases to go and hit the case and read the case law, the court's name, to make sure, number one, that it has something to do with the case that you're talking about. Number two, you can see where they, get their thoughts from that allows them to make the decisions that they make. But that JL, that's a good case. And this California case, I didn't look at that. I just looked at the JL case. And then it had several cases in there that led me to other cases that I read that was pretty interesting. Still, Officer Mercury's knowledge that Copeland was a convicted felon, active in a local gang, known sometimes to carry a gun, and prohibited from gun possession is relevant to determining whether the totality of circumstances here satisfy the 2-step inquiry required for evaluating the reasonableness of an investigative stop under Terry v. Ohio. And you'll hear a lot of people talk about the Terry principle, and that was a case in Ohio where they did an unlawful search on Terry, and so now that's a law that they speak on a lot. And then here's some other case law. It's very interesting. Once you start reading one case, you start learning lingo and information, real information, and you can kind of understand how their thinking processes are and how and why they make the decisions that they make. Okay, and then they got the United States v. Acosta, and that's from the 11th Circuit in 2004, summarizing established precedent holding that the first step of the required two-part inquiry is to determine whether the officer's action was justified at its inception, which turns on whether the officer had reasonable suspicion that the defendant had engaged or was about to engage in a crime, and that the second step is to determine whether the stop went too far or matured into arrest before there was probable cause. A lot of things, because we don't know and we get so scared, we think that we have to succumb to a lot of stuff. But one of the best things I've ever heard, and that is from attorneys and from people that have been involved in the judicial system, is what one should do if ever approached by the police is to exercise their rights under the Fifth Amendment and be quiet. Now, that does not mean you don't use your voice to identify yourself if you're under arrest. But you got to understand, look up the laws in your state to see when do you have to give your identification and stuff like that. But at any point that you're being detained, it is said in the penal code, and you're under arrest, then you have to at least answer who you are to identify yourself. If they start asking you questions about something, you have the right to remain silent, and you can exercise that right. Those are the people that seems to end up coming away with a better outcome than the people who think they're being friendly and having small talk with the police. Because one of the things in Miranda, it tells you that anything you say can and will be used against you in the court of law. What you don't understand is the way they do their reports and stuff may not be accurate to what you said. And when they get in court and they're the only ones with documentation and you're not, then who do you think the people are going to believe? The one who wrote it down supposedly when it happened, or the one who now, a year or two later, sitting in court saying that that didn't happen? And it's just like a lot of the shootings that has happened involving law enforcement and citizens. Had people not had their cameras and videotaping, a lot of the reports that they turned in about that person, then they say that the person did this and did that and this and that and this. And then the next thing you know, once a video come up, the officer has to change his entire report. Why do you think that is? It's reasoning behind this. And what they teach us is to be honest and to be integral, and you should be that way because that's who you are. But one thing you will learn, a lot of people that come, especially professional and in law enforcement, not all, but a lot, they come in there because they have permission to get the conviction by any means necessary. And believe it or not, they will lie. I mean, it doesn't matter the profession. And one of the things that they love to say to, civilian citizen is that, who you think they're going to believe? The nurse, the doctor, the police, the worker, whoever, whatever their profession, or you? And a lot of people get afraid. And there you go. They give up their rights. So you got to really listen to what's really happening. Okay. So it says, summarizing, established precedent holding that the first step, I just read all of that, engaged in the crime, and that the second step to determine whether the stop went too far and matured into arrest before there was probable cause. Citations and internal quotations omitted. The evidence marred as it is by the serious conflicts in testimony as to the visibility of the firearm in the H&M bag within the gymnasium and the viewing of the bag is not sufficient to establish either of the officers' plain view of the weapon, and indeed, Officer Hayes denies such a view existed. But on the other hand, the totality of the circumstances here still meets the relatively low evidentiary threshold for establishing reasonable suspicion for an investigative stop. And so because of his past and the things that the officer knew of him, then that still gave rise to reasonable suspicion, even though it was low. So, we have said repeatedly that courts must look at the totality of the circumstances of each case to see whether the detaining officer has a particularized and objective basis for suspecting legal wrongdoing. This process allows officers to draw on their own experience and specialized training to make inferences from and deductions about the cumulative information available to them that might well elude an untrained person. Although an officer's reliance on a mere hunch is insufficient to justify a stop, the likelihood of criminal activity need not rise to the level required for probable cause, and it falls considerably short of satisfying the preponderance of the evidence standard, and then give you case law for that. The court notes in particular that the officer saw that defendant was the sole individual in the gym wearing the True Religion jeans identified in the tip, and also playing basketball as referenced in the tip. That an H&M bag similar to that described in the tip was present in the gym, and that Officer Mercury was personally familiar with defendant's prior gang activity, carrying of a gun, and his felony conviction that legally barred his possession of a gun. The totality of circumstances here would provide an experienced law enforcement officer with an objective basis upon which to conduct a preliminary, brief, limited investigative stop under the standards set forth by the Supreme Court in Arvizu and Navarrete. Though the court recognizes the record clearly is more tenuous than that upon which the magistrate judge relied. The court further finds that the detention was not so extended or intrusive as to mature into an arrest. And then they give you the case law. Considering 4 factors to determine whether the line between a Terry stop and an arrest in an individual case has been crossed, the law enforcement purposes served by the detention, the diligence with which the police pursue the investigation, the scope and intrusiveness of the detention, and the duration of the detention. Citations omitted. Number 7, the evidentiary record established reasonable suspicion must be measured without reference to the actual identification of a weapon or by what the officers knew before they conducted their search. And that goes back to Florida v. JL. To the extent that the magistrate judge relied upon a finding that Officer Mercury had actually viewed the weapon and a finding of exigent circumstances and public safety in reaching his conclusion of reasonable suspicion, the court declines to adopt these findings based upon the current status of the record before it, as further discussed. Infra. Number 8. In reaching this finding, the court must rely on the current status of the record. If other evidence were to materialize and impact the court's assessment of the nature of the interrogation that occurred while Copeland was held in custody in the patrol car, the court will have to revisit its assessment of this finding. The search of the H&M bag. Number 2. The magistrate judge set forth a variety of legal grounds for sustaining the legality of the search of the H&M bag, including the plain view doctrine, public safety, exigent circumstances, and abandonment. For the evidentiary reasons already discussed, the court finds the evidence too contradictory and ultimately insufficient to support the R&R finding that the search was justified by the weapon being purportedly in plain view. The magistrate judge found that defendant had abandoned the H&M bag and relinquished any reasonable expectation of privacy in the bag because Copeland had left an unsealed bag with its contents visible in the community gym, exposed to the public. The R&R also found abandonment based on Copeland's silence when Officer Mercury asked, while standing next to Copeland, whether the H&M bag belonged to anyone. Courts may find abandonment when the evidence supports a finding that the suspect voluntarily discarded, left behind, or otherwise relinquished his interest in the bag so that he could no longer retain a reasonable expectation of privacy with regard to it. And then they give you case law. Whether the abandonment has occurred is a question of intent that may be inferred from acts, words, and other objective facts. And then there is a lot of case law right there. The determination of whether an individual has a legitimate expectation of privacy in the property requires a careful analysis of the facts of the particular case, and the individual's expectation must be justifiable under the circumstances. Case law is given. The government bears the burden of proving abandonment. Case law is given. The court is not prepared to reach a finding that defendant abandoned the H&M bag simply by virtue of his placing the H&M bag on the bleachers while he was playing basketball. First, the court cannot properly consider evidence as to the handling or movement of the bag captured by a video available days later, when this evidence clearly was not known to the officers during their short window of time in the gym. The officers themselves saw the H&M bag sitting in only one spot on the bleachers, in some proximity to the basketball court. Copeland was meanwhile playing basketball. Second, based upon the totality of evidence presented, the court cannot find that the bag was open rather than sealed at the time Officer Mercury looked at it and allegedly could see it was open and viewed its contents at the gym. Indeed, Officer Hayes specifically noted that the bag was sealed. Third, the court is not prepared to adopt the broad general proposition suggested by the R&R that a member of the public abandons his privacy and Fourth Amendment interest in his satchel once he lays the bag down in a public community center and temporarily moves away from the bag, whether to play basketball on the adjacent floor, go to the restroom, or gossip with a friend, several rungs down on the bleachers. In the court's view, a finding of abandonment of the Fourth Amendment protected privacy interest requires a more factually specific manifestation of abandonment of the property at issue, exceeding the owner's mere temporary placement of a bag on community basketball court bleachers while the owner remains present in the same room for a relatively short duration of time. Thus, in United States v. Sparks, the court sustained a finding of abandonment where the evidence indicated that defendants made a conscious decision to stop pursuing recovering of their phone within the 3 days of having lost it. And in Bernstein, and that's an appeals case, the finding of abandonment was in part based on the defendant's hiding his bag in an unrelated private entity's warehouse where he had no reasonable expectation of privacy or access since he was a trespasser in the course of flight. In effect, the magistrate judge in Bernstein found that the defendant did not have a legitimate expectation in maintaining his privacy, instead in the bag, because he had hidden it in a private location where he was a trespasser and where he had no reasonable objective expectation of privacy. Nor does the video indicate Copeland saw that others had opened and looked into the H&M bag. Number 10, the phone at issue contained you-know-what images of a child. Although the court declines to find that defendant per se abandoned the H&M bag on the bleachers, it concludes that the government has satisfied its burden of proof, if by a slim margin, to show that defendant Copeland abandoned his interest in the H&M bag when, in response to Mercury's sarcastic inquiry, he did not respond that it was his bag, and thus disassociated himself from the bag. The court recognizes that Officer Hayes did not recall hearing Mercury's voicing this inquiry when the court posed the sole question directed at the topic during the supplemental hearing. But it is certainly possible that Hayes simply did not recall Mercury's brief question or did not hear Mercury's question amidst all that was going on in the gym in a condensed time frame. In evaluating Hayes' lack of recollection of Mercury's inquiry of the crowd, the court finds that this difference between Hayes and Mercury's testimony, while of concern, does not rise to the level of the particularized differences in their testimony as to their views and handling of the bag. Hayes affirmatively testified, as opposed to not recalling, regarding the condition, contents, and collection of the H&M bag, which conflicted with Mercury's testimony on the same points. Based upon the above findings, the court need not reach or adopt the R&R findings that the search of the bag could be justified based upon public safety and exigent circumstances. Number 11. Application of the exigent circumstances and public safety exceptions here presents a host of thorny issues. The presence of a semi-automatic high-velocity firearm in a community center presents clear risk as a general policy matter. Yet Georgia law authorizes the carrying of weapons with few limitations in public spaces. The court cannot therefore say that these risks alone per se create such exigent circumstances as to constitute reasonable grounds for suspicion of the Fourth Amendment's warrant requirements. And the court notes that the government must demonstrate both exigency and probable cause to establish emergency or exigency as a basis for conducting a warrantless search. And they give the case law out of the 11th Circuit. The government would be pressured to argue the, the existence of probable cause in this case without reference to the actual seized UN. Officer Mercury himself expressly indicated he had released and not arrested Copeland because the police did not know whether the weapon belonged to Copeland. A strong argument has been made here that the officers had inadequate, objective, specific information upon which to find probable cause as to the imminent commission of a crime, or alternatively, as to the capture of an individual suspect of recently effectuating a violent crime. And then they give case law. Citations omitted. Finding exception to Miranda's prophylactic protections was justified by paramount safety issues when police officers chased into a supermarket an armed ape suspect just identified by a victim on the street, and where the suspect was wearing an empty unholster, and where the police officer posed only one question concerning the location of his UN. We have found the warrant requirement of the Fourth Amendment inapplicable in cases where the exigencies of the situation make the needs of law enforcement so compelling that the warrantless search is objectively reasonable under the Fourth Amendment. And the facts here are distinct from Holloway, where the warrantless search was conducted after two separate reports of continuing gunshots and people arguing at the defendant's home that reliably suggested the threat of imminent danger to human life. They give case law. Is similarly distinguishable. There, the 11th Circuit found that the police permissibly searched the motel room of the defendant, a violent offender with a previous criminal record, when they went to arrest him for the non-fatal shooting of his wife and child, and the defendant identified the location of the UN. It would defy common sense to allow the officers to question Newsom as to whether there was any threat and then prevent them from neutralizing the threat. The UN was found as a direct result of Newsom's statement. Probable cause had been established in these cases. The court nevertheless recognizes the significance of the concerns raised by the government and magistrate judge regarding the presence of a semi-automatic UN in a public community facility where at least one of the individuals present, who is Copeland, had a record of gang and felony activity. Number 2. We're almost at the end. Defendant's detainment in the patrol car and questioning by police. Officer Mercury placed Copeland in the back seat of his patrol car after leaving the Dunbar Center and then viewed the contents of the H&M bag in the trunk. After a hostile crowd from the center had gathered outside, Mercury became concerned about security. He then proceeded to transport Copeland to the Turner Field back parking lot, a location within a few miles of the Dunbar Center. Hayes did not accompany Mercury, but instead departed for a different location in his own separate vehicle. I think that's strange, but that's what they said happened. Officer Mercury testified at the first hearing that a crowd of people from the gym had formed outside the Dunbar Center and was getting pretty hostile and agitated, so he relocated his vehicle with Copeland handcuffed inside to Turner Field. At some juncture during the car ride, Copeland radioed investigator, and I don't believe they meant Copeland there because that's the defendant. I think they meant Mercury radioed investigator Lakia Gaither with the APD gang unit to meet him at Turner Field to talk with Copeland. Mercury testified at the magistrate judge's hearing that Copeland was upset and had asked to speak with Gaither. All that sounds so fishy to me, but who am I? Whom Copeland knew from prior police interactions. Mercury's investigative report, on the other hand, specifies without any reference to Copeland's request that when he was relocating to the Turner Field location, Mercury, notified the gang unit whom arrived on the scene, and that's more of the truth, to question Copeland about the weapon and other gang-affiliated activity. That's more along the truth of thought. That doesn't mean that really happened. I mean, he just could have been covering his own behind, because the way he's telling the story now, it makes no sense. And Officer Mercury also testified that his detention of Copeland was for investigative purposes. Copeland remained detained and not free to leave the vehicle after Gaither and members of the APD gang unit came to speak with him. The record at this juncture does not indicate that Copeland made any substantive statements separately to Mercury prior to Gaither's arrival, though he made statements regarding the once Gaither arrived. Mercury did not turn on the car's recording device while Copeland was confined in the car. Isn't that strange? That's why they have those devices, so that everything is transparent. Now, supplemental hearing testimony of Mercury. 13. Officer Copeland testified that he apprised investigator Gaither, and they mean Officer Mercury because Copeland is the defendant, investigator Gaither, of the situation briefly over the radio. 14. Yet Mercury stated he had insufficient information to arrest defendant, but personally never conducted any further investigative questioning, either while Copeland remained handcuffed in his patrol car as they drove to Turner Field, or during the approximately 20 minutes that elapsed as they waited for Gaither's arrival after arriving at the stadium, or during the additional time after Gaither spoke with Copeland as he continued to sit in the locked car. Investigator Gaither testified at the first hearing that as soon as she arrived at Mercury's patrol vehicle, she leaned in to talk to him and through the car window and asked, "What's up? You asked me to come out." That just sounds like a lie. I mean, that sounds like a Clint Eastwood movie or something like that. Jason Bourne maybe, but that didn't happen, in my personal opinion, and I have the right to have a personal opinion. You can see how they don't tell stories according to their reports, and it's ironically she didn't show up at the supplemental hearing. She was only there at the beginning. That's why the supplemental people couldn't rely on certain things. According to Gaither, Copeland started ranting about how he had just gotten out of jail, had done nothing, and did not have an and transcript citations therein. Gaither arrived along with various other members of her APD gang unit to speak with Copeland. Both officers, Mercury and investigator Gaither, maintained in their testimony that Copeland's statements were all provided on a completely voluntarily basis. Okay. Okay, the officers were bearing arms in their holsters at the time. The government concedes that Copeland was in custody at the time that he allegedly requested to speak with investigator Gaither, and when they spoke on April 28, 2015. None of the officers ever advised Copeland of his Miranda rights at any time on April 28, 2015. Defendant Copeland was released after Gaither had completed her conversation with him. They let him go, but they thought that was his bag with the machine on. As discussed by the magistrate judge, normally the officers would have been legally obligated to administer Miranda warnings prior to questioning him under these circumstances. Here, however, Officer Mercury testified at the hearing before the magistrate judge that he did not question or obtain any statements from defendant Copeland, and that Copeland independently requested to speak with investigator Gaither. Regardless of whether Copeland requested to speak to Gaither, if Mercury actually heard no statements made by Copeland and Mercury cannot testify to any, there is nothing to be suppressed. So I guess Mercury got out of his car and walked away once she came. Ooh, this don't make sense. Thus, the court agrees with magistrate judge's finding that defendant's motion to suppress statements made to Officer Mercury must be denied based on the current record, subject to an evidentiary shifts that may occur at or before trial. And then 15 tells you about Miranda, that's Miranda rights. And then 16 is Mercury did testify before the magistrate judge that he heard Copeland stating to Gaither that the on was not his. Therefore, the court's analysis of Copeland's interaction with Gaither will dispose of whatever statements Mercury actually heard. Based on the current status of the record, the court also agrees with the magistrate judge's legal and factual analysis that Copeland gave a spontaneous and voluntary response to investigator Gaither's inquiry of "What's up?" that was not the product of interrogation or its equivalent. The court previously requested that the government make Gaither available to testify at the supplement hearing, but she was on leave or otherwise personally unavailable around the time frame of the hearing. The court proceeded in her absence. Her supplemental testimony would have assisted the court in addressing the hanging question posed by the magistrate judge's report as to Gaither's dialogue with Copeland regarding the on when she arrived at the patrol car that was also apparently overheard by Mercury. Specifically, to the extent that investigator Gaither questioned Copeland about the firearm seized at the Dunbar Center, as opposed to merely seeking clarification about a spontaneous statement regarding the firearm without having provided him Miranda warnings. Then his responses to those questions would be subject to suppression. But on the current record before the court, Copeland has not shown that such an interrogation occurred. Accordingly, the court denies defendant's motion to suppress his statements to investigator Gaither, subject to hearing from investigator Gaither prior to any trial in this matter, in the event that the government intends to present her testimony as to statements made by Copeland on April 28, 2015. Officer Mercury testified that he detained defendant in part to conduct further investigation and that he had radioed investigator Gaither to meet him at Turner Field. Gaither then arrived at Turner Field with several additional officers from her gang unit and appeared outside Mercury's patrol car. This sequence of events, as well as the content of Officer Mercury's investigative report, at the very least, suggests that investigator Gaither approached the defendant Copeland with the intent to conduct an interview and interrogation. Number 3, defendant's statement upon his arrest on June 10, 2015. Defendant Copeland has moved to suppress evidence seized and his statements made upon the execution of arrest warrants on June 10, 2015. He contends that this evidence should be suppressed as the fruit of his illegal detention an effective arrest on April 28, 2015. Based on the court's findings herein that the officer's conduct was lawful on April 28, 2015, defendant's argument fails. The court agrees at this juncture with the magistrate judge's summary that defendant's contention that there was no probable cause to arrest on June 10, 2015 is without merit because none of the evidence that established probable cause for the arrest warrants was tainted. Defendant's motion to suppress evidence and statements in connection with his June 20, 2015 arrest are therefore denied. In conclusion, for the reason discussed, the court adopts in part the magistrate judge's report and recommendation. Although the court declines to adopt portions of the R&R findings and analysis, the court concludes that defendant's motion to suppress evidence and statements and must be denied. However, the court will revisit immediately before or at trial outstanding questions concerning investigator Gaither's dialogue with defendant and any other defendant statements made while in custody in Officer Merker's patrol car on April 28, 2015. The court notes that its ruling regarding the legality of the detention, search, and questioning at issue here are potentially subject to further modification based on additional or conflicting evidence that may be presented at or before trial. And then he gave the case Newsom. The court sets this case for trial to commence on Monday, April 2nd, 2018. The pretrial conference will be held on March 16, 2018 in courtroom, and by March 1st, 2018, the parties are to file the following motions in limine and propose voir dire questions. The government must file a brief summary of the indictment that the parties can rely on for voir dire. By March 8, 2018, the parties are to file any objections to those items listed above. The court notes that defendant has filed a motion seeking an order in limine, allowing the defendant to present evidence at trial to establish the defense of justification. The government is directed to file a response to this motion by March 8, 2018. The time from the date of this order to April 2nd, 2018 shall be excluded from computation under the Speedy Trial Act, pursuant to, and they give the law. Failure to grant this continuance would likely deny counsel for both the government and defendant the reasonable time necessary to effectively prepare for trial. Taking into account the exercise of due diligence, the court finds that the ends of justice are served by granting this continuance and are consistent with both the best interests of the public and individual justice in this matter. It is so ordered January 22nd, and that was the end. So, after hearing that, I don't know if anybody who started out with me is still here with me. What do you guys think about what happened on that day when they had him in that car? Do anybody have any opinions? Any thoughts? If not, we'll move forward. So, we've covered that part of the Young Thug trial. There is a YouTuber that I like looking at, and he's talking in reference to Adriane Love, which is the district attorney on Young Thug's case. She's an assistant district attorney. And one of the things that Nick says, I'm going to share this because it's very interesting. And I also put that in the description And y'all should check Nick out if you want to follow Young Thug and somebody that give you a different view. I like his commentary. In my opinion, he's pretty fair. And all you want in life is for someone to be fair. So let's hear some of Nick. And he titled this, "And If You Need Another Reason to Dislike Adriane Love."
This is from The Appeal, and the headline says, "Medical staff at notorious Atlanta jail let autistic teen waste away and die," lawsuit says. Now, why do I blame Ms. Love? Because she is ultimately responsible for keeping him there. At 15, Shane Kendall, an autistic child with bipolar disorder, schizophrenia, and intellectual impairment, allegedly fatally shot his mother, which is a tragic incident. His father is on his son's side. It was a terrible, terrible accident. With murder before he turned jail. During the last years of his life, Shane Kendall, an autistic teenager, was locked up inside Atlanta's notoriously dangerous Fulton County jail. In an interview, his parents told The Appeal that when Shane turned 18, he was sent to the adult unit, big boy jail, as he called it. He wouldn't survive the year. On January 31st, 2021, roughly a month before his 19th birthday, officers found Shane curled up in a ball on the floor of his cell, according to a wrongful death suit his father, who goes by Joel, filed earlier this year. The suit alleges that Shane asked to be placed in a different cell, but when the officer denied Shane's request, he assaulted his cellmate, who later reported that Shane told him he'd start a fight because he wanted to get out of the cell. Guards then gave Shane a notice that he was facing 48 days of disciplinary lockdown, essentially a 24-hour-day solitary confinement, according to the complaint. The next morning, officers found Shane unresponsive from an apparent self-ending attempt. Joe's suit alleges that the jail's medical providers employed by the for-profit coffin company NAF Care failed to render life-saving care and neglected his medical needs throughout his incarceration. The suit names NAF Care, 2 medical providers, several sheriff's office employees, Fulton County, and its sheriff Patrick Lebat as defendants. I would actually, but here's the thing. Ms. Love as prosecutor is probably immune, even though I personally hold her directly responsible for this. When the nurse arrived at his cell, she refused to perform CPR, saying she had a bad knee, according to officers' reports, with one officer noting that he was alarmed by the nurse's refusal. Well, nurse, whoever you are, why are you a nurse? Well, why are you a nurse at all? And if you have a bad knee, if you can't provide your nursing capabilities, then off you screw. Give the position to somebody who actually wants to perform their job. The physician's assistant, who arrived more than 10 minutes after staff discovered Shane's body, was described as disoriented in one supervisor's report. Unlike the nurse, he brought an automated external defibrillator, which recommended no shock, according to the complaint. NAVCare has faced similar accusations of neglect from incarcerated patients and their loved ones. In the last 5 years, the company has been sued more than 300 times in federal court. But despite the ongoing controversy surrounding the for-profit company, Fulton County commissioners on November 15 last year voted to renew the contract through the end of 2024. From January 1st through December 31st, 2024, Fulton County will pay NAVCare more than $33 million. I assume those $33 million are the cheapest they can get. The county also recently recognized the, quote, NAVCare team of healthcare heroes for going above and beyond to save lives during a serious incident at the jail, end quote. Really? I would say that is, there are bad press. Let's create some good press to counter it. Screw you. Fulton County Chairman Rob Pitt said in a press release posted on NAVCAR's website, the medical providers were awarded the Fulton County Chairman's Award. His own award. Oh, he is ultimately responsible for keeping hiring them, and then he gives them an award. So for some reason, that should make everything go away. No. In court filings, NAVCare has denied all wrongdoings in Shane's case and asked the court to dismiss the complaint. The sheriff and county have also filed motions to dismiss. The court has not yet ruled on their motions. The Fulton County Sheriff's Office, which operates in the jail, told the appeal in an email that it does not comment on pending litigation and would not say if the medical providers were still employed at the jail. That means they are. The office of the Fulton County Attorney emailed the municipality had no comment in response to the question sent by the appeal. Attorneys for NAVCare did not respond to requests for comment. Shane's parents hope their lawsuit will help protect others at the jail. I sadly won't count on it because it seems like Fulton County Jail and the people who run it have no souls. They are probably going to church as everybody else, but they are completely empty inside. It's not just about Shane. There are so many lives in there. Shane's stepmom, Margie Thorpe, told the appeal. The fact that we still contract with this medical company to take care of these people or not take care of them is a crime. That's giving government money. That's taxpayers' money. And remember, Shane, presumed innocent until trial. Shane's criminal defense attorney, Rachel Kaufman, who also represents Shane's dad in the civil suit, told the appeal that the teen should never have been sent to the Fulton County Jail. In addition to autism, a developmental disability, Shane has been diagnosed with bipolar disorder, schizophrenia, ADHD, and intellectual impairment, according to medical and court records. Kaufman's co-counsel in the criminal case, Daniel Kane, told the court during Shane's first competency hearing that Shane was hallucinating during one of their initial meetings. Kane testified that during his 40-plus year career, he had only raised concern about clients' competency in 3 cases at the Fulton County Jail. Shane reported to medical staff that he experienced visual hallucination when in closed spaces. Hello, Mr. Jingles. Hello. Say hello to the audience. Say hello. Jingles, say hello to the audience. Jingles. Say hello to the audience. Yeah. Hello audience. Hello audience.
One thing I can say about cat lovers, they really love their cats. He's going to talk a little bit in a minute about Adriane Love and her role in this.
Yes. Oh, he looks so happy.
And I guess we can say hello, Mr. Jingles, from the Tiger's Den.
Yeah. Joe testified that he never expected Shane to be able to live independently. He said the teen had received therapeutic services since he was a toddler. He had a list of mental problems as long as your arm, and they have been documented since birth, Joe told the appeal. When Shane was less than a week old, he was placed in foster care and went to live with Joe and his ex-wife. They adopted him a couple of years later. If there's ever anyone who should have been treated as a mentally ill person rather than a criminal, then it's Shane Kendall, Joe said. And here is the lawsuit in itself. If this video gets recognized enough, I will do a reading of that. So hit the like button, hit the subscribe button, comment below that you want to see more about this. At 15, Shane allegedly picked up a loaded gun left out at his adoptive mother's house. She and Joe had split up years earlier and fatally shot her, said Kaufman. Joe did not receive his medication when he stayed at his mother's house, according to Joe's complaint. Despite his well-documented history of psychiatric and developmental disabilities, the Fulton County District Attorney's Office charged him as an adult with murder and other offenses. Kaufman told the appeal she begged and pleaded with the prosecutors, then under the leadership of former Fulton County District Attorney Paul Howard, to agree to have him placed in a psychiatric hospital. But they fought.
And this happened before Bonnie became the district attorney, and when she had quit the district attorney's office to have her own private office. But she had worked in the office for 16 years, so keep that in mind. But she didn't have anything over this situation alongside of this assistant DA. So let's keep going.
Every step of the way, end quote. At the first competency hearing, Assistant District Attorney Adriane Love accused Kane and Shane's father of lying about Shane's disabilities. All his life, medical records throughout his life, and Adriane Love claimed they were lying. I cannot with words describe my dislike of Adriane Love. And remember, this happened before Fannie Willis took office. I believe. Because this happened in 2019. I want to say it's 2019. At 15. Yeah, 2019. Adriane Love, blah, blah, blah. Which prompted Kane to file a motion for the court to find her in contempt. Kane told their appeal that Love's accusations were completely unethical. Yeah, I agree. When you have all these medical history, all these medical records, and claim they are lying, she's only saying that in hope to persuade the judge to get him in jail. And apparently, she succeeded. I don't know who the judge was, but I sure as crap hopes that person is no longer a judge, but I assume he is, or she. During a closing arguments at Shane's first competency hearing, Love said that Shane's legal team was, quote, trying to get you to feel sorry for Shane Kendall. Jesus Christ, you cold-hearted B. You have no soul, Adriane Love. You can do this and then walk out and be a normal human being if you argue like this. You can't. Maybe that's why she is so angry all the time, because she has nothing inside. No soul whatsoever. Let's see here. Quote, he's had all of these problems, Love said. I'm not saying he hasn't had a hard life. I'm saying he's competent to stand trial, and they haven't proven otherwise. Hallucinations, autism, everything in between. Seriously. She told the jury that his medical history and diagnosis were, quote, irrelevant in proving, quote, unquote, whether or not he was competent to stand trial, and that he was only at a psychiatric facility, quote, because his parents have lobbied to keep him there and the state hasn't objected, end quote. You are not a human being, Miss Love. You cannot be a human being. Because humans have souls. You do not. However, the 2018 court order that sent Shane to the facility states that a psychiatrist found Shane incompetent. See? That should be the end of the story. Both counsel for the defendant and counsel for the state agreed that the defendant should be transferred to the facility for psychiatric treatment to see whether restoration of competency can occur. Yeah, because all these can be cured? No. I mean, he will always have autism. He will always be bipolar. He will always, or, well, not anymore, but he will always have these. The feeling of restoring competency, that's just a middle management kind of way to claim, yeah, now you can stand trial. It's a bogus thing. At the end of Love's closing, she said she'd like to, quote, add this book. No. She then played an excerpt from one of the Spider-Man movies in an apparent attempt to underscore her argument that Shane was malingering. No. Jesus Christ. First of all, if you are playing from one of the Spider-Man movies without the license, you just committed copyright fraud or copyright, whatever it's called. Kaufman did not make similar attempts at, quote, levity, quote, unquote, in her closing remarks. Quote, I am boiling with anger and frustration, she told the jury. How low are we going to go? And the state is willing to go pretty low. The state's default position has been to win at all costs, to ignore ethics, morality. That hearing ended in a hung jury. Kaufman said she hoped the prosecutors would change course and not retry the case. Instead, they took Shane to trial again. This time, the jury found him competent to stand trials. Why is this handled by laymen? Why? How can a jury find this? They do not have the medical expertise to find this. This should be a matter of law, not as a matter of as a fact finder. This is stupid. And Miss Love, I bet you know it's wrong. I bet you know it's wrong, but you do it anyways because you are so empty inside. You are so soulless. So you fill it with garbage in order to feel something. Maybe it's enjoyment for you, Miss Love. Maybe it's enjoyment for you. Maybe you go home in the shower with a pulsating shower head and think about this. I don't know. You have no soul. And the jury, Jesus Christ. I hope you read anyone in that jury. If you are watching this, apologize. Go to church immediately. Tell your priest that you did a fundamental evil thing, and beg for forgiveness. Beg for it. Case said he won't love what would happen if Shane went to jail. Quote, I told her, this guy is not going to make it. He will not live, he said. And damned if I wasn't right. If he goes to jail, I said something will happen. Shane's case breaks my heart every day, Kane said. I wake up with it in the middle of the night. Love, who stayed in the prosecutor's office after Fannie Willis defeated Howard in 2020, is now the chief deputy district attorney for the high-profile cases and difficult witness division. She did not respond to request for comment. Maybe she was busy in the shower. While Willis has become a darling of some Democratic circles for using the state's racketeering law to prosecute former president and several of his associates, she's also drawn fierce criticism for using that same law against musicians. And now they are going into the Young Thug trial. Yeah. Horrible. Horrible. Yeah, and then they go into lyrics, which, by the way, the Georgia Supreme Court said, can't do that. But George Glanville doesn't care. Maybe it's because he has no spine and he's a coward. And he is too afraid to stand up against soulless Miss Love. Here's the thing. Okay.
I'm going to stop it there and you can finish watching the video. You can go over to Nick's and I have it again in the description so you can just go and get it and look at it to see the rest of what he's talking about. Here I want to share
tonight hundreds.
They're talking about this lady keeps bringing these detectives and she has a list I showed you guys of all of the witnesses she wants. And these detectives that she's bringing were trained at the same academy with the same instructions. And these are people that supposedly from the gang unit. And this is where the judge told them that they're beginning to be repetitive and cumulative. So I wanted to play this from the news. Atlanta News First. Let me share this right quick. I want to thank you guys for staying with me for this period of time. I certainly appreciate it. We're almost done for the evening.
of witnesses lined up and ready to take the stand in the ongoing YSL trial. But the Fulton County judge overseeing the organized crime trial wants to speed up the case and potentially limit the number of witnesses. Atlanta News First, Rachel Aragon was in the courtroom where defense attorneys are raising questions.
Attorneys for Jeffrey Williams, a.k.a. rapper Young Thug, taking issue today with testimony from one of the state's witnesses as they claim testimony sounds very similar to what jurors heard not too long ago. Before a former Atlanta police detective returned to the stand on Monday.
Your Honor, there's no need for this witness to be an expert.
Jeffrey Williams' defense attorney motioned to strike her testimony from last week. The state's witness, who used to work in Atlanta Police Department's gang unit, is testifying as a fact witness and court-certified gang expert.
All she's doing is corroborating and supporting her co-worker.
Williams' attorney says the witness is giving identical testimony to the state's previous court-certified gang expert.
I moved to strike the testimony because it is repetitive, cumulative, and prejudicial.
Prosecutors say they still have 3 more experts to call up, but that no 2 experts of theirs are the same, with each having different training and backgrounds.
The fact that these investigators came from the Atlanta Police Department, but they are not the same people without the same experiences, in no way should disqualify them.
The judge denied the defense's motion to strike the former detective's testimony, but warned the state that some of their witness testimony is getting repetitive.
Since a foundation has kind of been laid already as to some of this, it needs to be more focused. The next 3 folks.
And the former Atlanta police detective also testified about a 2015 shooting. The trial is expected to continue tomorrow morning. Reporting in downtown Atlanta, Rachel Aragon, Atlanta News.
And lastly, I want to bring to you all's attention that I mentioned before in the last video where Fulton County DA was asked to participate in the debate from the Atlanta Press Club. And they do this, I guess, every election season. Of course, she declined because she was speaking in Miami at peace officers conference of something to that nature. And so I want to just share a little bit of what you saw, if you witnessed, and if you didn't, what happened at that conference. So let's take a look at that. And we won't do too much because, of course, she wasn't there. So, you know, it wasn't a real debate. Give me a moment. Let me pull this up. I had it already gone a little bit past that part. So then we didn't have their music. And so this is the debate. I wish people in Atlanta are really paying attention. And like I said, in every city, major city, there are problems with the jail system, with the court system, with the district attorneys, even defense attorneys being willing to take certain cases because they have to practice in these judges' courts. And we really don't understand the dynamics of what's really happening. It just behooves us to educate ourselves, learn as much as we can learn. We don't have to do what they do, but we definitely need to know what they should know. We don't have to know it all, but we should be able to go and look it up and read. It will help us tremendously. So I want to just show y'all the beginning of this, and then we'll get ready to say good night. And again, I thank you all for staying with me as long as you have. And share this video, like the video. I thank y'all for liking the video so far. And leave a comment. We didn't have a lot of activity in conversation today, but of course I did a lot of reading. So I just want to thank everybody who came and stayed, and be sure and share. One of the great things about being on YouTube is that we are known by the people that come to our videos, that engage in the conversation, and that shares. And no matter how small or how large, as long as YouTube see that people are engaging and being a part of, then it really helps us as content creators. So for that, I'm truly grateful. Let's listen to a few minutes and then we'll say goodbye.
Makers on Georgia Public Broadcasting. Welcome to the Atlanta Press Club Loudermilk Young debate series from the studios of Georgia Public Broadcasting. This is the debate for Fulton County District Attorney. Let's meet the candidates. Christian Y. Smith is an author and attorney. Bonnie Willis has served as Fulton County District Attorney since 2021. Ms. Willis declined to participate in the debate and is represented by an empty podium. Now let's meet our panelists. Tamar Hallerman is a senior reporter for the Atlanta Journal-Constitution. And Sam Greenglass is a politics reporter for WABE. For complete rules on today's program, please visit the Atlanta Press Club website, atlantapressclub.org. To start the program, the candidate will be asked one question by each panelist. He will have 60 seconds to answer their questions. Sam Greenglass, you get the first question to Christian Weiss. Smith.
Hi, Mr. Weissmith. Thanks for being here. The Fulton County Jail is housing hundreds more people than it was designed to hold. Last year, 10 detainees died there. Most have not been convicted and are just awaiting trial, sometimes for months or even years. The DA is not responsible for conditions at the jail, but Fulton is still trying to dig out from a massive case backlog after the pandemic that reached more than 200,000 cases in 2022. What's your plan to address that backlog?
Well, the district attorney does have something to do with the backlog, and the district attorney can do something about ending mass incarceration, right? When we see people dying in the jail, when we see the terrible conditions in the jail, when we see people sitting there for too long unindicted, that's absolutely a problem that the DA can try to fix. And one of the ways we do that is we create diversion programs for cases involving substance addiction, mental health, homelessness. Those are things that we can bring people through the system a lot faster to alleviate those problems in the jail and also address the backlog.
All right. Tamar Hallerman, please ask your question to Mr. Weissmith.
Thanks for doing this, Mr. Weissmith. 4 years ago, you ran on a criminal justice reform platform that included things like not seeking the death penalty, ending cash bail, and not prosecuting many types of drug possession cases. Do you still take those positions today?
I've grown a lot in the last 4 years. You know, the biggest way is understanding that crime is an issue that impacts all of us, so we should all have a seat at the table, right? I want to be community-based and bringing the business community on board to help provide internship opportunities and job opportunities for people so that we can break the cycle of recidivism. I want to partner with all of the public schools in Fulton County so that we can be proactive and just showing up for our kids to help dismantle the school to prison pipeline. And, you know, having community resource providers, again, to address issues of homelessness, mental health, and substance addiction. Those are all things that we can do differently than we aren't seeing being done now. And if you want to say that those are progressive and bold, I still stand on that, and I do still stand on not seeking the death penalty and other progressive measures to make sure that Fulton County ends up becoming the safest county in the country.
That concludes the first round. In the second round, the candidates asked questions of each other. Since Fonnie Willis declined to participate, Christian Y. Smith, you may pose a question to the empty podium. You also have 30 seconds to provide a rebuttal to how you feel your opponent would have responded.
Hey, Ms. Willis, how you doing? My question for you is, where are you? You know, I'm here because I care about the citizens and the families of Fulton County, but it's my understanding that, you know, you may have attended the White House Correspondents' Dinner, you may be fundraising across the country, but what about us here in Fulton County? What are you doing to address the issues in the jail? What are you doing to address the backlog? Where are you, Ms. Willis? That's what we want to know.
Do you have a rebuttal?
Well, you know, I can't speak for Ms. Willis, you know, as she's not here. And I think that her absence is all the response that we need.
All right. That concludes our second round.
Okay, and you can finish looking at the debate. And I have that link, I believe, in the description. It's real long, but I cut it off and put in there that you can look it up, and you should be able to hit it and find it. This is what it looks like in Fulton County. A month before it's time, well, it's really less than a month. They go to vote on the 21st of May. And it's really sad that she chose not to participate in the debate, but she, I guess, had prior engagements. So, you know, people have to do their schedule accordingly. But this is the danger that we have when we don't know who we're voting for and what they're standing for. Tomorrow is going to be a big day, and I can't wait. I'm anticipating the cross-examination of Detective Sergeant, Lieutenant, whatever her type is, Gaither. She's no longer with the police department. As a matter of fact, it was said that she left with a big exodus of officers, and she left and went and worked for the DeKalb County DA, being an investigator. So a lot of people say that they love their job and they're doing what they were called to do, and they're supposed to be making a difference. And it seems that a lot of people are going for the money, prestige, and titles. And so I can't judge what these people are doing. I can just tell the story. And, you know, we are going to draw our own conclusions. And that's what I suggest that everybody do, is draw your own conclusion. On that note, I put up these pictures so we can see the officers that lied at one hearing and didn't show up for the other hearing. And so we'll never know if their stories are the truth or the lie. But the young man, Kenneth Copeland, I believe he's known as Woody, and he's supposed to be one of the star witnesses. And they tried their hardest to knock DK, Mr. Murphy, out of the park. But I think that he stood strong, and he took responsibility for his actions. You can call him what you like to call him. I call them a lot of just young boys that grew up in an environment that they adapted to, whether they wanted to or not. And without opportunity, then things happen. There's no excuse in when you break the law. Of course, there are consequences to your actions, which is the same as when you break your parents' rules. It's not necessarily the law, but you got to learn to take accountability and responsibility for yourself. And we have to be good stewards and hold you accountable and responsible, and then give you consequences for your actions, because the world is not going to view you like your mom and dad. And we have to know that, and we have to continue to teach that. Even though it seems a lot of children are being reared by the internet now and by the games that they play, and they seem to have no respect for themselves or no one else. And so we have to look at ourselves and see, what could we do different? And what we can do different is just be a part of something great and speak life into these children instead of all of the other stuff that's going to come their way. And that's my 2 cents. We have a lot of good people covering this story. The Real Dinah and Judge Joe Brown, they do a good job in covering the story. Teddy Nash does a good job in covering the story. I think now a little bit Phil Holloway, and he has an attorney that visits him, Rachel. They're doing pretty good on covering the story. Professor Nez, he covers it a little bit. He's more into the Trump story than he is this one. But a lot of good people are covering this story. And then the mayor in Dalton, Illinois, has just gone berserk. I may start covering a little of that. Her right-hand man has been indicted for fraud, bankruptcy fraud. And I understand now that she may be looking at something soon. They have been subpoenaed, a lot of people. And so it's actually happening for those people. She's literally almost bankrupt the town. She took them to a $7 million deficit. And these are small towns. I don't even believe they have over 100,000 people. And so it's really sad what we're seeing throughout the nation. And I think it's kind of good for us to see it, because we always know that the European is not right, we say. But look at the people that we help put in office that look like us, that we say is going to make a difference. Yet they go in there and do some of the most outlandish stuff, and they're not making a difference for the good. So on that note, I'm going to leave the Tiger's Den. Again, I thank you for staying with me. I'm going to leave with my favorite, Greatest Love. And I'm going to say good night. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us who we used to be. Everybody's searching for a hero. People need someone to look up to. I never found anyone to fulfill my needs. A lonely place to be. So I learned to depend on me. I decided long ago never to walk in anyone's shadow. If I failed, if I succeed, at least I'll live as I believe. No matter what they take from me, they can't take away my dignity, because the greatest love of all is happening to me. I found the greatest love of all inside of me. The greatest love of all is easy to achieve. Learning to love yourself is the greatest love of all. And if by chance that special place that you've been dreaming of takes you to a lonely place, find yourself in love.